the first episode, I emphasised the need to be clear about the treaty parties. I explained that nativity rather than ethnicity is where native rights are derived from, and on that basis the treaty was between the Crown and the indigenous natives. In the second episode, I explained that sovereignty was the right to rule over a defined territory and its population. I also argued that sovereignty was variable. For example, the sovereignty of the natives on North Sentinel Island is not of the same quality as the sovereignty held by the King over the British mainland. A proposed right to rule should face the question of what exactly is being ruled, and the answer to that question is reflected in the rights and rules that apply in the territory in question. In this third episode, I'm going to discuss some issues around the possibility of sovereignty of the native tribes of New Zealand and what native rights arrived from that sovereignty in the Treaty of Waitangi. The first issue, and a very serious one at that, is the way the British Crown conducted its international affairs circa 1840. The British Crown purported to recognise some form of sovereignty held by the natives before the treaty was executed. But what was that exactly? Well, prior to February 1840, about 30% of the territory of what became New Zealand had been sold to European settlers by the native tribes. By recognising native sovereignty, the British Crown was implicitly recognising that the natives had a sovereign right to dispose of their tribal lands as they saw fit prior to the treaty being executed. The treaty itself recognises a theoretical sovereignty that is capable of being ceded. However, following the execution of the treaty, the British Crown nullified these pre-treaty land sales and seized the land from the settlers. By doing this, the British Crown were implicitly stating that the natives did not have sufficient sovereignty to freely dispose of their tribal land. To reconcile this contradiction, the only possible interpretation is that the native sovereignty recognised by the Crown was a right to rule that did not extend to the right to freely dispose of native tribal land. The Crown's position was that the natives' power to dispose of their own tribal lands pre-treaty was limited to disposition to the British Crown. To cast a better light on what else the British Crown thought were the sovereign rights of the natives, the treaty itself is informative. The treaty is neither complicated nor ambiguous. The first clause is a straightforward recital of a legal standard catch-all clause. It means the British get everything. The first clause clearly illustrates the point that the British did not and could not determine the status of native sovereignty. That's why it refers to sovereignty that the chiefs may be supposed to exercise or to possess. The second clause then sets out in very orthodox manner the exceptions to Article 1 and the conditions attached to them. In particular, the natives retain the full, exclusive and undisturbed possession of their lands and estates, forests, fisheries and other properties. There are a few points to cover here. First is appreciating the difficulty of determining what the natives actually had. In 1066, the British mainland was taken by conquest. The new king, William the Conqueror, ordered the creation of the Domesday Book. This was essentially a stocktake of mainland Britain. Well, in 1840, the British were in no position to do a native Domesday Book in New Zealand, nor was there the certainty of proprietorship in the native territory such that a sensible Domesday Book could even be written. There are also points to be made about the treaty reservations for native holdings in New Zealand. In 1840, the British did not regulate sea fishing in Britain. However, since at least 1066, fishing rights in lakes and rivers in Britain had been proprietary and belonging to the landowner. In Britain, rivers cross private land, but in New Zealand, rivers intersect private land, and no one owns the fishing rights. This has to be considered when determining what fisheries are referenced in the treaty. The British elite doing the treaty bargaining would have had a mindset informed by their own societal conditions back in Britain. This is reflected in the treaty when the Crown takes preemption on fishing and hunting rights. As I have argued before, Offshore deep-sea fishing rights are not something the natives ever had sovereignty rights over. And I extend that argument to stating that the fisheries referred to in the treaty are at their highest, fishing rights covering pre-existing native species in lakes and rivers, intersecting the lands that the natives possessed. Forests have to be looked at in the very same light. In Britain, landowners have gamekeepers and own hunting rights in their privately owned forest. The king owns all animals that are not otherwise owned by somebody else. There is no such thing as a wild deer in British forests, in the sense that we would find a wild deer in New Zealand. Without applying a romantic socialist interpretation on the Treaty of Waitangi, I frankly cannot find any nexus between the native rights and radio airwave spectrums, offshore fisheries, whale watching, commercial logging, or any of the other plethora of perks given to people who have a partial native ancestral link to someone who was born in what is now New Zealand prior to 1840. The third article of the treaty is another one that has been subject to controversy. The Queen extended her royal protection to the natives. This has been interpreted as imposing an active duty on the Crown to protect the interests of people who among their various ancestors has one who was born into a native tribe in the territory before February 1840. This tenuous ancestral link is considered to result in a special relationship with this group of people over and above the relationship between the Crown and people who have no such ancestral link. Well, this I can say unequivocally is wrong in law and fact. The instigators of this myth are simply delusional and rewriting history to suit a socialist narrative. The key is in the word extended. Her Majesty did not make any new or novel protection for this particular group. She simply extended her existing protection, which refers to the rule of law, to cover the new territory of her realm. You don't need to troll through years of academic masturbation to understand the simple concept of extending state protection to a new territory. The truth is that Her Majesty doesn't play favourites. Yes, there is a special relationship and a duty to protect, and that applies equally to everyone of all ethnicities. It is the orthodox protection that exists between a sovereign ruler and all of his or her subjects. The treaty, on my reading, is a simple document that sets out a very orthodox set of reservations as native rights. It takes the orthodox view that the natives were, true to their native status, part of the flora and fauna of the territory with no overarching sovereignty. The treaty sought to extinguish any perceived sovereignty over chiefly domains while reserving in perpetuity, and subject to preemption, the proprietary rights to those territories over which native chiefs held chiefly dominion, including fishing, hunting and gathering rights. The present ideological interpretation of the treaty goes well beyond what I think was intended by the treaty parties. One of the problems with determining what native rights might amount to is answering the simple question of what is a native. And if that sounds like a Matt Walsh documentary, you're not wrong. And I'll be discussing that in my next video, which you can be notified of when it drops by hitting the subscribe button. Give us a like, would you? Thanks for watching. I'll catch you next time.